Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Natalia Angelini.
And I'm Anchal Bajaj.
Welcome to Hull on Estates. You're listening and watching episode number 645. And today we're going to be discussing mediations, and I'm happy to be doing this with Anchal. It's our first time podcasting together. I hope you're looking forward to it.
I'm super excited as well.
And we're going to have a good discussion about mediations. And we thought about this because we have a recent Ontario decision that was arising out of a mediation. And we've also got an earlier Supreme Court of Canada case that we wanted to chat about that it has some related issues. So, Anchal, do you want to dive into the facts?
Sure. The first case we'll be discussing is Québec v. Bouvier. Hopefully I said that okay. Here, the court discussed settlement privilege. There were two common law spouses involved in mediation agreements. They were from Quebec. They were negotiating the terms of their settlement. So it's important here to know in Quebec, mediation is court-ordered. So during mediations, which occurred over several days, the mediator prepared a summary of mediated agreements between the spouses, and both the husband and the wife signed the agreement. But after, when they went to court, the wife seeked more money than was agreed upon in the mediation agreement. And at this point, the mediation agreement was brought into under the settlement of privilege. So this means that they would need to agree upon that one, a settlement was agreed and under what terms, because those were being contested. And the court found that even though mediation is confidential, there are certain exceptions to this, and therefore this falls under the settlement privilege.
Right. And so what was at issue was whether or not an agreement had actually been arrived at, right?
Yes.
And so that specific scenario, the court had the ability to see the mediator's summary and help it get clarity on the actual issue, right? And be able to consider the issue properly. And so we can have a link up to that case on our website. And relatedly, we've got this Ontario decision where what's this case name? It is Campbell and Gautreau. It's a recent case, a June 2022 case. And again, in this situation, there was a settlement agreement and a tussle over the settlement agreement, right, Anchal?
Yes.
And so tell us what happened there.
In this agreement, there was one of the individuals who was self-represented, and there was someone else, and they were represented by counsel. And here again, an agreement was reached. And after the agreement was reached, there was an email confirming the terms of the settlement, and the self-represented party agreed to those terms. But when it was time to sign the agreed upon terms, the self-represented party backed out. So,
right. I think to put a finer point on it, when the minutes were signed, right, the terms were agreed to, it was when the release, or the consent rather, to the dismissal order had to be signed that one of the parties didn't want to proceed.
yes.
Right. And so this issue came before the court. The opposing side brought a Rule 49 motion to enforce the settlement. And it's somewhat different from this Quebec situation because there was, I guess, more clarity in terms of an actual agreement having been reached, right? We had terms that were documented in writing, confirmed in writing as an agreed upon settlement, but a failure to fulfill those follow-up steps, right? Those settlement steps. And so what happened? What was the outcome of that Ontario decision?
The court applied the four-part test, where one looked at if there was a genuine mistake in terms as to the terms of the settlement. The second point was if there was a misunderstandings of certain fundamental facts, which in this case wasn't found. If there was any duress under signing because an agreement was signed, and if the agreement was illegal.
Right. And so the court had decided, looking at all these factors, that the agreement should be enforced, right?
Yes.
Yeah. And I mean, it's a good reminder to us when we go to mediation. It is often just a really important point in litigation where everyone's together. You've got this unique opportunity to try to creatively craft a settlement that the parties have control over. And then once that happens, sometimes, right, people are tired, you've tussle over some minutia sometimes, and a settlement can collapse. Or it's agreed to and someone has buyer's remorse, right, and changes their mind. And that's where these kinds of fights happen. And it is a reminder to me to always make sure when we go to mediation, we're prepared. We've got our draft minutes, we've got our draft releases, and everyone is signing on the dotted line there. I mean, there's not much you can do about someone who changes their mind after the fact, but you can control what you do at mediation and having all your paperwork there. So an agreement is at minimum properly documented, and it will, really strengthen your ability to enforce it, right? If you have to bring that enforcement motion, when you've got assigned material, it puts you in a better place to do that successfully. Right, Anchal? I mean, in estate matters, what do we see people fighting over in estate? What do we see that, I mean, I can think of cases where we settle all the big stuff and then there's a fight at the end about photographs or memorabilia, the small things, the teacups. And it's just such a shame to see settlements unravel over that sort of thing. And so, and sometimes it can unravel over monetary issues too, which I believe was in this case, the Campbell and Gautreau case.
Yes, it was also in the Quebec and Bouvier case where she wanted additional support payments. I think it's just important to remember when you agree upon a settlement, you can't change your mind later. You should really think before you agree, because you can't just later be like, I don't want to enforce this settlement anymore. You already.
Right. Though it is a confidential and without prejudice process. Once you've got that agreement in place, you're going to be held to it. So Anchal, unless you have any other thoughts, I believe that concludes our podcast.
We want to thank you for listening in and for your time. If you have any questions, please email us at info@hollandhall.com or contact us through our contact page.
Thank you. I'm Natalia Angelini.
Thank you. I'm Aanchal Bajaj.
Take care.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hollandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.